and I am live on the gram. Yeah, I'm outside on my new patio. Shit is nice and relaxing, getting some fresh air in the whole nine. Um, yeah, yeah. The IRS is making it a rule where they can't have no personal information of none of their agents or none of their communications because it's tax injunction. The tax, y'all better do the tax injunction ASAP. They are changing laws to make sure y'all have to keep on paying taxes. Where if you do the tax injunction, you ain't gonna be paying no taxes, right? Go to jonahbay.com to pick that up. You want to go get that ASAP, yo, because when they implement the CBDC, which is the Federal Reserve uh, wireless money system, they're just going to take taxes out of your money, whether you like it or not. You're going to have, see, if you do the injunctions now, you're going to be grandfathered in. They can't do that to you, right? But I'm warning y'all, y'all are running out of time like a motherfucker. But I would love to read the article to you, but it ain't letting me read the article. I'm waiting for Solar to send me the article a different way, like download it to me or something like that. You know what I mean? But welcome. You're listening to the Jonah Bay Show. Now, I always say this, but I'm gonna say it again. Yo, y'all newbies, y'all gotta study more. Even the old people gotta study more. A brother sent me this. He said, peace to the God. If you're doing the accord and satisfaction process and they send you the check that says full satisfaction or claim on it, if they send it back, then what you do, right? That means he has not been in the archives whatsoever and listened to not one show on accord and satisfaction. Because, and he hasn't even read the law of accord and satisfaction, which is UCC 3-311, right? So if they send the check back, let's look at how. If you look at number two of accord and satisfaction, it says the claimant, whether or not an organization proves that within 90 days after the payment of the instrument, the claimant tendered repayment of the amount of the instrument to the person whom the claim is asserted, the paragraph does not apply if the claimant is an organization and sent the statement complying with the paragraph. So it's saying if they send you your money back, accord and satisfaction didn't work for you. Read the laws. I'll say it time and time again. Read the laws, stick to the laws. That newbie should have known what the law said and should have known that the accord and satisfaction didn't work. It's two ways it don't work. It's if they send you your money back, and also if they had an address that you had to send it to directly and you didn't, it won't work. It also won't work unless you did a bona fide dispute before you did accord and satisfaction, right? I don't know why y'all are making me teach the same things over and over again when the lessons for the newbies is already in the archives and you will get a full lesson there. Right now, what am I doing? I'm answering the question, but it's summarized. I'm not even reading the whole UCC 3-311. And on your state level, they got accord and satisfaction. All you got to do is Google Georgia accord and satisfaction law, New York accord and satisfaction law. You know what I mean? That's how you going to find it, man. Y'all got to put in the work. The problem is y'all want shit fast. Y'all done messed yourselves up for a long time. Y'all gonna have to give yourselves times to learn what y'all need to learn to get stuff done, right? So I wanted to say that. The other thing I've been dealing with, I've been telling y'all to read Tricks and Traps of the Court. Too many of y'all ain't reading it. Y'all getting consultation asking me about various different cases and y'all not knowing what's going on. Yo, Jonah, I did it exactly how you told me to in the template and all that, but they still moved ahead. I said, yo, they use tricks and traps. I told you read the tricks and traps of court. What you think they're gonna do soon as you put in the law, they just gonna give up? These people are thieves and robbers. You know what I mean? That's like saying, yo, Jonah, I got a lock on my house, but someone still broke in. Yeah, locks are made to keep honest people honest. Locks ain't gonna keep a thief out. A thief gonna get into your house no matter what. And that's what the court system is. Thieves, yo. They're gonna try to wiggle out of it. It's up to you not to let them use their tricks to wiggle out. So let me read this. Hold on, let me put it in the chat so y'all all can get a copy and read it. You know what I mean? Y'all ain't doing enough homework, man. And that's why y'all not getting the remedies that y'all be trying to get if you let them use petty tricks on you. All right. So there it is. It's in the chat on YouTube. It's in the chat on Blog Talk, the Gram. Y'all gotta Google it. All right. It says tricks and traps used by attorneys and judges and other species of rats concerning evidence. The rats have laid a minefield of tricks and traps of the unwary, uninitiated, and ignorant pro se litigant who dares trespass on the monopolized realm of Texas courts by skillful manipulative use of the rules of the court of judicial interpretations of the rules, and the lawyers, with the complicity of the judges, are able to get their hearsay evidence entered into the record as facts, deprived of the ignorant pro se of his evidence. When the other side can get whatever they want, including hearsay admitted into the record as evidence, the pro se cannot get anything into evidence. The outcome is going to be obvious. You can't win without evidence to prove your case. Now, if y'all go to the archives, I done told y'all about this case a many a time. Supreme Court case, Trincy versus Pagliaro. If you Google Trincy versus Pagliaro, it's going to say that lawyers cannot put any evidence because it's all hearsay because they don't have first-hand knowledge at all. Why is it that a newbie that went in court knew that and bust the court's butt, but you older people or some other newbies ain't getting it done? Because she put in the work to listen to the old show. She knew what she was talking about. Y'all don't, right? So nothing he says is evidence. Nothing. Even if he comes with evidence dealing with you, it's not evidence until you say it is. You're the only one who could say that's you. You're the only one that can say that's your name. By the way, the illegus is not you and it is not your name. This is why I teach y'all to always ask them, are you talking about the illegus name or the natural person? And they're never going to answer that. So they're never going to get proper jurisdiction either, which means dismissal in the end. But they're going to try to trick you other ways to get jurisdiction. But then it goes on. Let's say, let me finish reading. When you can't win without evidence to prove your case. This does not seem to be fair in the interest of justice, but fairness of justice has nothing to do with the operation of Texas courts. The pro se litigant is expected and required to follow the rules. The pro se gets no slack from Texas courts. The party acting pro se must comply with substantive and law and procedural rules. And the case number is CAT Will 1995 918 SW2D 9 and 10. If you are ignorant of the rules and how the rats manipulate the rules, the rats will invariably strip you of your property, steal your children, throw you in prison, or all the above. And the rats will have done nothing wrong in the eyes of the courts. You should have hired an attorney, they will say. However, the final outcome might as well be the same if you had one. Even if a litigant wins with the aid of an attorney, often the only difference in the final outcome is that the attorney, not the adverse party, ends up with all your money and property. Either instance, you will have been impoverished and reduced to a pauper by the Texas form of justice. You can win, but you still be the loser. The following information and authority is found scattered through and is taken from O'Connor's Texas Rules Civil Trials 2001, published by Jones McClure Publishing, Inc. Now, if you're reading this, you're supposed to automatically Google O'Connor's Texas Rules of Civil Trials 201. Go get the book and read it to master going into court. I shouldn't have to tell you you need to pick up the book because obviously this guy is pulling from that book. All right? Let me go on. It's published by Jones McClure Publishing, Inc., accepting the comments in the brackets. This is the best rule book concerning Texas rules of court, and the author has seen. The author has seen. Now, what you got to remember is, just because it says Texas, all states are pretty much the same. The overall picture is the same, right? Because it got to be uniform by Uniform Commercial Code. All right? Let me go on. It is filled with annotations and explanations of rules and procedures for Texas courts that can be found in no other place. If you want to play in the Texas courts, you should have a copy. And it may be ordered by calling 1-800-626-6667. They also publish a book containing forms for pleadings. It is imperative that the pleadings be properly drafted, or else you will surely lose. The essay is in no way intended for legal advice. If you want legal advice, hire an attorney. If you know a competent one that you can trust and afford, otherwise, do your homework. I'm saying the same thing. Do your homework. Do your homework. Be ready. Right? I'm going to read one more paragraph and then we're going to go into getting questions asked and stuff like that. Even though it's Jonah Bay show, I still let y'all ask questions today. So next paragraph, how attorneys' unsworn statements become facts of evidence and how to prevent it. The trial court has a discretion to omit or exclude evidence. The appellate court will reverse only the abuse of discretion standard. See National Lab Fire Inc. Co. versus Allen 2000. City of Brownsville versus Avardo. If the trial court sustains or the objection, it will not admit the evidence. The party who offered the evidence still have other options that it must exercise, or it waives the error. If the trial court overrules the objection, it will admit the evidence. If the party whose objection was overruled still has other options that it must exercise, or it waives the error. An attorney unsworn statements are not evidence. U.S. Government versus Marks, 1997. However, the appeal A lawyer unsworn statement can be considered as evidence unless the other side object at the trial. Banda versus Garcia, 1997. Normally, attorneys' unsworn statements must be under oath and must be considered as evidence. Banda supra, if a lawyer is presenting facts to the court, the other party should object and ask the lawyer to be sworn or subjected to a cross-examination. Banda supra, when in doubt, a lawyer should always object to the fact or statements of another lawyer. If the other party is aware that the lawyer is testifying and does not object, the administration of the oath is waived. Fullenwider versus American Gar and Lab Inc., 1991. Now, the newbie that I'm talking about in court, and if you want to hear that audio of the newbie, I'm talking about that did great in court with learning my lessons, go to my my Patreon, Jonah Bay, at Patreon, and you can hear the audio. And she did great. She brung up Pagliari versus Trinsky that he can't testify. Asked him to be sworn in and all of that. Now that it's time for to ask questions, I'm gonna play a commercial real quick. I'm gonna go pee, and then I'm gonna open up the call lines. So y'all can finish going over this Wednesday. I want to make sure y'all hear the whole thing, because I can't trust y'all to go and study the tricks and traps of court. So I'm gonna do it for you. All right. So I'll be right back. Here's a commercial.
Are you dealing with a legal situation? Are you being stopped and questioned by police for no reason? Got you feeling like the deck is stacked against you? You can get everything you need to protect yourself, your rights, and your property at JONAHBay.com. You can learn how to remove that so-called judge from your case with the writ of penitence and assises webinar and template. Get that so-called judge out of here. You can learn how to save your money so you can make money with the Discharge Webinar DVD right here at JONAHBay.com. While you're there, you definitely need to pick up the injunction webinar and template. Don't believe me? Check this out.
Peace to the gods. You're now listening to the sounds of Hindsight Radio.
I want to share a story regarding the injunction. I did the injunction, and I was stopped by the police. I didn't realize it. So he said ticket, and so he went to his car and ran my plate, and I literally mean he almost ran back to my car with my license and said, "Have a nice day," and sent me on my way.
What happened to the ticket, though? Where's my damn
no ticket. He sent me on. He told me to have a nice day and sent me on my way. So the injunction does work.
Go visit JONAHBay.com.
At JONAHBay.com, you can choose from a wide selection of webinars, seminars, templates, certified documents to get your remedy. He can teach you how to go ahead and get out of debt. And not only get out of debt, but to be self-sufficient where you don't need to go ahead and utilize the system. You are the system.
JONAHBay.com.
All right. We back from break. So let me open up these call lines and get it cracking with the questions. I'm going to first caller. It's 636-249. Peace to the God. Peace.
Peace to the
What up, God? How are you?
all right. How you doing? Here?
Huh? Yeah, I can hear you.
Yes, before. All right, here we go. I can hear you.
That's what's up.
Good show so far.
Thank you.
I I definitely heard you last week talk about the woman who went to court and she hit him with everything that you showed us. I can't wait to get to the actual recording here. My question was when it come down to like student loans, and my bad, so I can't even hear it really. But when it comes down to student loans, we also make like Fed loans. We make them obligated.
Fed, you got a Fed loan, they definitely obligated.
I knew it. I knew it to make sure.
United
Definitely
States is obligated to the American people because they took a loan from the American people to pay off their debts. And that was the gold and silver.
Okay.
And then they gave you promissory notes, which y'all call Federal Reserve notes. If you read your constitutions, Federal Reserve notes are not constitutional money. Constitutional money
Right.
is gold and
Yeah.
silver.
Right.
So check it. They had
money.
you, in 1933, they had you turn in all the gold and silver coins. And they also had y'all turn in all the paper money that said redeem in silver or redeem in gold in the treasury. So they took all your money. Now, the money back then was considered receipts for gold and silver because it said you could redeem it in gold and silver. Yeah, so they took that away. So you had no way of getting gold and silver, and they took the gold and silver you had out of circulation. Which reminds me, they are coming out with reverse ATMs. What they're going to do is allow you to put money in the machine, and it's going to give you a card where your card, you can spend it anywhere that doesn't accept cash. That's how they're planning on trying to get the money off the streets. Y'all,
well, you know what?
Don't
like
use that damn
bank
machine. Don't go to stores that you could only use credit.
I was just reading something about repo bank, like bank repos. Like when the bank receives a wire from the Federal Reserve, this is what they've been doing. Some places, the banks turn around and be like, "No, we don't want to be obligated." Did you know that? I checked that out just a couple of days ago.
Mm-hmm.
They will be indicted.
Right.
Indicted. So they definitely trying to do something with this money. But
yo, dog, I mean, just like what I was saying at the beginning of the show, the IRS is protecting themselves with all their workers because they know taking y'all's money through taxes is unconstitutional. That tax injunction, I laid out everything that made it unconstitutional. See, I cannot take a piece of your labor, right, and give you nothing, or that's slavery. And that's what they've been doing because money represents your labor.
That's the one thing I gotta get on. That's like everything else I'm on top of. I got to get to that. So I'm gonna get to that in like 3 weeks from now. But anyway,
yes,
one other thing. If I have a relative that just got 40 months, Fed time, and the thing is just this: you get the 14 days appeal. I'm not sure if his attorney appealed it or not, but even if he did not appeal it, because they're gonna get 78 months at first, so they prepared to 40. The dude, he only got caught with some guns and a small amount of like less than $1,200 worth of stuff on him. And so my thing is, he's a good dude. I mean, he got a scholarship and everything, but went to the streets. So my thing is can I hit them with Rule 12, constitutional challenge, even if he does not do the appeal in time?
If he doesn't do the appeal in time, see, he's supposed to exhaust his administrative process, and appeals and all of that is part of that, right? You can do 241, 242 suit against these people, but that case will pretty much be over.
So by then it pretty much be over.
Yeah. Now, just like I was reading in that book, Tricks and Traps, right? That PDF. When you do an appeal, they're only going to look at the paperwork you already did and make procedural decisions on procedures, right? This is why I always tell y'all got to put in the Constitution. Y'all got to assert what rights you had from the Constitution, which if y'all use my discovery, you have that. And then to preserve it, you got to put in what's called opportunity
judicial notice.
No, motion to appeal discovery.
Oh, okay.
Motion to appeal discovery. And then once they do that, you ask for a motion to dismiss and put a date for the hearing of your motion to dismissal. Put a date, because lately they trying to make it seem like y'all don't put in the hearing date. So it's wrong. It's not wrong. They were supposed to put in a hearing date, but you're going to put it in just like you did in judicial notice.
Okay, it's like last week. Okay, you're right. Okay, so it sounds like lay down the alphabet for me right there. But did you say to me that it's like a lost cause? Or if
you missed the appeal, and especially if he didn't put enough in there to prove that they did procedural errors. See, you got to understand, Constitution overshadows all their rules, codes, and regulations. Their rules, codes, and regulations supposed to be in accord with the Constitution. So as long as you bringing out procedures they didn't do with the Constitution, you're gonna win on appeal.
There we go. Okay, that's all I needed to hear. Shay, peace of God. Thank you.
All right, peace, God. Someone asked me, Jonah, look like you in the back room. I'm not in the back. I'm in my actual gazebo. I'll give you a quick look around. That's the truth. There must sails up there. I'm outside. See what I'm saying? I'm totally outside. Yeah, it was too nice for me to be. Too nice for me to be sitting inside, so I went outside. I like to ground myself, so you know what I mean. The energy of the earth can flow through me. I'm going to 408-761. Peace to the God. Peace.
Peace, Bay.
Peace, God.
I have a couple questions. If the school calls you in, or he or they say that to go in for the court, how do I get the money? Or how do I sue them?
You would have to sue, and you said the school, you suing them for what?
Oh, because I have my son with me, and I guess he missed like a whole week of school, and they called my ex, and they told her that they wanted to see us. They wanted to go into court and to see why he has been absent so much.
Well, first of all, so, I would alleviate the problem. If he missed a week of court, what you need to do is get a doctor's note, right? And then after that, I would sue them for getting in my business. And what you would be suing them under is a lack of privacy. Everyone has the right to privacy. It's a constitutional protected right, right? So them trying to, if the kid was sick and you said he was sick, that's all it should have took, right? For them to call people and stuff on you is a violation of your privacy.
And the other one, this is if I'm going through the annulation of marriage, and they don't want to give me a court date, how do I proceed through that? They said to get the.
What you trying to do? Get a divorce?
Center. And yeah, this is for me, but I went in and they.
Are you trying to get a divorce?
Pardon?
Are you trying to divorce?
No, annulment. she's married in Mexico, and then she got married with me after 10 years later, and she's not even divorced over there. So I want to annul. So I already put in the paperwork, but then the clerk told me that in order to finish the annulment, I have to go through the what do you call it, the self-help center, and put in the whatever I make, how much I make, and how much she makes.
Hell no. Yo, what you're going to do is draw up an affidavit and put the proof in the affidavit that she was already married and all that, right? Then you're going to notarize it, get it on the notary authenticated, and you're going to run it in the newspaper. Let it run for 3 weeks. After 3 weeks, you got your annulment. If it goes uncontested, then you take it down to the county and take it to probate and put it into probate. All right, then, peace. And your phone sounds terrible. We could barely hear you. All right, I'm going to the next caller. I'm going to 612-382. Peace to the God. Peace.
Peace. Can you hear me?
Yes, I can. Your phone sounds wonderful. That's that AT&T with that Apple phone.
I don't mess with Apple only. I do mess with their computers a little bit. But peace, shalom. I got a question. Where we saying the or a social security number to the for example, life insurance company. Is there any particular etiquette?
Nah, bro. You doing life insurance, they're gonna tap into that account. Give them that social, man. You want your money. I ain't did no tricks with that. I gave them the straw man.
What is there any
now they do
like
have a process. They do have a process where you can use a trust account, right? But they still gonna need a social to draw that money from.
Exactly. All right. So is there so as far as like the etiquette when that comes up with the social with the life insurance, then I always feel like I need to explain it to them, and it really always goes fine. I just explain to them it's not mine. I didn't apply for it. I never claimed it, and I don't claim it, and I never will claim it. But here's the number.
I ain't doing none of that. Just give them the social. What the hell do you do all this paperwork I taught you for? You know what I mean? You already got paperwork where, you know what I mean, you gave the illegals to your express trust, right? You already did your claim a lien on the straw man. You already did a fucking promissory note from the straw man to the trust. The first lien holder of that straw man is supposed to be your express trust. If you done all that, you ain't got nothing to worry about. You already did your tax injunction, so you ain't paying no taxes. And not to mention life insurance, you don't pay taxes on. Then if you've done all the stuff I taught, you ain't got nothing to worry about. You feel me?
I mean, I bought all the shit, but I ain't follow it yet.
You need to start doing it, putting it in motion.
I ain't paid this type of tax in over 20 years, right?
Right.
But and you know, nobody's chasing me down. You know, nobody's beating my door down. You know, I don't think they want to actually raise the argument with me because I think that they probably believe that they have a good chance of losing, and that it would create some negative precedent that they would then be under. So they don't want to try it with me because I've been telling these fools for over 20 years I'm not a resident citizen of anywhere.
Right. Just use. There's no way to get that life insurance policy without giving them that number. Give them the number.
All right, well,
there's no way for you to get a EIN that you can do business with online without giving up that social. Give them the social. You got the 98 number and all that, but it won't work to do commerce on the computer. Certain things you're gonna have to do.
Is there anything else that we should have on that list in our mental? You know what I'm saying? We got the EIN, the life insurance, anything else where we're gonna need to stipulate, or I shouldn't say stipulate, but refer to that number?
See, what you gotta remember is this. This is everything you gotta remember for real. The Enligas is not you. In truth, you don't even have a name. What happened when you were born is your mother created the Enligas with the hospital, and that's the name that's been available. And you've been using that name thinking it was yours, but it was never your name. So when you do what I taught you how to claim your nationality, you take on a new name. And the new name doesn't have any social or birth certificate. Now, you're supposed to what? Go get an EIN, the Express Trust EIN for that name, right? And in my original non-UCC, I showed y'all how to take over the birth certificate and do a new one and do a claim of lien on your new name, right? So you are actually whole nother person in commerce. Now, when you set those things up, you're only supposed to be using the new name to do commerce, right? But when you're talking about insurance and shit like that, that's the straw man. So think about that when you're doing all deals. You know what I mean? You got to separate yourself from the straw man completely. And that's called public and private.
How about Jonah Bay's 12-step program to quit that servitude? It's a 12-step program, so we get the 12 steps numbered. So first we're gonna.
I've already taught it. I've already gave. That is the most asked question. Is what's all the steps? The fact is, you start from number one. Once you do one part, which would be authentication and injunction, then I'll give you the second, then the third, then the fourth. I got to make sure you do all the steps. So if you didn't do that, you're missing steps.
The injunction come before the name change?
Hell yeah.
Oh, I didn't know that.
I know.
What I'm saying, the 12 steps. So
I just told you what you have to do.
We're going to have to pay for the info.
I just told you what you had to do.
What steps come first and later.
I just told you what you had to do. What did I say?
The injunction.
I told you the injunction and what else?
Well, I got the authentication done.
And
so
then what else I said?
The name,
See what I'm saying? You only hear what you want to hear. I told you after you do those things, you supposed to contact me and ask me what's the next thing to do. I'm never going to give you the whole thing. Why? Because y'all never do it right. I make y'all go step by step. When you go into school, they first make you go to kindergarten. You can't go from kindergarten and then go to the third grade. You got to go kindergarten, first grade, second grade, third grade. Y'all are trying to move from the beginning to the middle or to the end. I won't let you. And if you do that, I'm not responsible for the results. I can only guarantee it if you're doing it a specific way in order.
Hey, so if I got that the deluxe, what's called
everything
that's got all the
yeah. You got all that stuff in that package, right? On jonahbay.com, right? But you still won't know which ones to do. You're gonna have to talk to me. Now, I don't care if you get a consultation or you ask me on the air like you're doing now every week. But you have to tell me, yo, I did this part and that part. Yo, what's the next step? But don't ask me, yo, do number 1 to 20. I'm not going to tell you 1 to 20. I'm only going to tell you 1 Then you do step 1. I'm gonna tell you step 2. Then you do that, come back. Now I'm just gonna tell you step 3, and so on and so forth.
All right, with the state and fed authentication done, then I got to do the injunction.
Yes, sir.
And
then call me back.
All right, bet.
All right, peace.
Peace to the guy.
See what it is, y'all. I'm trying to get people, especially the newbies, to do everything to be totally protected. See, if he'd have known the stuff and did the stuff, he would know that he could have used the straw man to go get the life insurance policy, right? And I want him to go get that life insurance policy. But we'll talk about it again Wednesday. I'm going to keep on going over tricks and traps of court. I enjoyed the show. I hope y'all did. I think I enjoyed being out here in nature, talking to y'all, hearing the birds chirp. I'm going to do this more often too. And that's our show for today. I'll talk to y'all again soon, Wednesday. Peace to the gods.
Thank you for using Blog Talk Radio. Goodbye. 60 seconds.
All right, YouTube. I hope y'all enjoyed the show. I know there's a whole bunch of people started tuning in. I must have started going in. 59, 58, 57. What you doing? I don't have that many things you have to do. I think I've never counted, but etc. You know what I mean? Do the right one so you protect yourself from all the different movements. Oh, you were counting down to the minute I get off? Okay. Okay, I feel you. All right, then I'll see y'all Wednesday then. Peace.